Mr. Keegan Miracle's on the line. Is Rebecca Costiato on the line?
Yes, I'm here, Your Honor.
Okay, well, welcome to you. Bear with me just one moment. I'm pulling up my notes.
Yeah, this matter was set out and given an extension for him to respond, but he hasn't responded.
Right, it looks like we were here 1 or 2 weeks ago, and then there's a request by Mr. Miracle, I believe, to submit additional information. Is that correct, Mr. Miracle?
Yes, sir.
And were you successful in submitting that information you wanted to submit?
No, sir. My family's been in mourning over my uncle, and my grandpa's still been in the hospital. And I have a ride to get up there and file tomorrow. I just hadn't been able to get up there until, my family's just been going through a lot.
So is your uncle still in the hospital?
My uncle had passed away, and my grandpa is still in the hospital.
Okay. And when did your uncle pass?
It was the Friday previous to our court case. We just held his funeral. Or, sorry, not 2 weeks ago, but sorry, I don't have the exact date.
Okay. And then you said your grandfather's in the hospital?
Yes, sir.
When did he go in?
It was the day before our court case, or about 2 weeks ago.
Okay. And Ms. Castellano, this is on your motion for adequate cause to modify the parenting plan, and also your motion for contempt. Is that accurate? Ms. Castellano, if you're speaking, I can't hear you.
I'm sorry, can you repeat that? It's cutting out.
Sure. My understanding of the reason.
I'm sorry, can you repeat that? It's all cutting out.
We're here just looking for you to confirm that we're here on your motion for adequate cause to modify the parenting plan and your motion for contempt.
Correct, yes.
Okay. What's your position related to the motion to continue?
Well, I think he's had plenty of time to respond. He was given extra time to respond. So, I mean, I don't see why it can't move forward today.
Is there any harm that you would suffer if there were to be a continuance?
I'm sorry, what?
Would there be any harm if the motion was continued 1 week?
Yeah, it was continued 2 weeks because I think our court was on the 13th.
Right. My question is, would you suffer any harm if the matter was continued one more week?
Oh, no, that would be fine.
Okay. I think given the circumstances here where Ms. Castellano, the moving party, would not suffer any adverse consequences to continuing, and with it sounds like the medical and passing of a member of Mr. Miracle's family seems appropriate. So, Mr. Miracle, you'll need to get your pleadings in promptly, and then we'll set it over to 1 week, which will be on. I'm asking if Ms. Looney is on the line.
She's having some technical difficulties on her end and has restarted her computer. Hopefully, we'll be on soon.
Okay, great, thanks.
Your Honor, my name is Ms. T. McKinney.
Yes.
I have a date today for visitation. However, my mother-in-law is, we don't expect her to last throughout the day today, and I'm at her house. Is there any way that we can postpone this 1 week or continue it over for a week?
Okay, and just to make sure, your name is Misty McKinney, correct?
That's correct.
And you're the petitioning party in the matter of Mr. McKinney versus Mitchell Stemmerman?
And Heather Fontes, that is correct.
If Mr. Stemmerman and or if Ms. Fontes is on the line.
Your Honor, Tiffany Jensen appearing for Ms. Heather Fontes. And my client was just served on the 15th of March, and she was served in Sherwood, Oregon. So we have 60 days to respond to this request in this petition. So I'd be asking the court to set it at least out 60 days so we can properly respond and reply to the motion.
I believe this was an order to show or a motion for an order.
It is a
petition.
It is a motion for order for visitation. As far as the summons, Ms. McKinney, when was the service effectuated?
She could be correct on the 15th. I'm not sure, Your Honor.
Yeah, it looks like it is March 15th. It looks like it was also served on, both Mr. Stemmerman and also Ms. Fontes on that date. All right. So on the 15th of March, so we'll set it out 15. And Ms. Jensen, is it your position that the summons has to be served within summons is served and then 60 days passage occurs before any motion can be brought. Is that your position?
Yes, Your Honor. I think based on my reading of the summons, my client has 60 days to respond to the petition before the court can take any action on the motion on whether visitation should even occur, whether Ms. McKinney actually meets that initial threshold.
And would you agree that if there was some type of emergency situation, the court could take action prior to that?
I would, Your Honor, but there's not an emergency situation. There's a case pending, a custody and parenting time case pending
Right.
between Ms. Fontes and Mr. Stemmerman. We have a guardian ad litem that's been appointed and we have temporary orders in place. So I would submit to the court that there is no emergency, that no one has filed anything relating to a situation where there is an emergency. This case is already being adjudicated in another court with an investigation pending. So based on those circumstances, I don't think there's any reason to proceed any sooner than at least 60 days.
Thank you, Ms. Jensen. Ms. McKinney, any response?
I do, yes. I think that it is not in the best interest of Hadley because she's used to seeing me every single weekend. I mean, like 3 to 4 times every, nights every single week. So I do think this is an emergency situation. Waiting that long after it's already been several months, I think is not good for Hadley. And I think it's for her psychologically. I think it'd be best to move forward to, decide as soon as possible.
Okay. All right. Thank you. In this situation, I'm going to grant the continuance. I'm going to set the matter over to May 15th at 9 o'clock in the morning. I find that there's not an emergency. Obviously, there's great concern by Ms. McKinney's part related to the well-being of the child and a continuation of maybe visitation patterns that have emerged in the past. But I find that it does not rise to an emergency. There's also 2 other matters that are at play. There's a family law matter in which there is a temporary parenting plan in place, and there's also a domestic violence protection order that's been in place and will be expiring in June. So we'll set the matter to May 15th. That'll allow Ms. Fontes to reply or respond to the summons and also respond to the motion. So the motion, we'll hear that on May 15th.
Thank you.
Thank you, Your Honor.
I'll ask everybody then. Thank you. Mr. Daly, if you're on the line, make sure you're unmuted and state your name.
Yes, Your Honor, I can hear you.
Okay. Welcome to you, Mr. Daly. And I'll ask if Shariah Nielsen is on the line.
Yes, Honor, I am.
Okay. Welcome to you, ma'am. All right. We're on today, and Ms. Looney is present. We're on today for Ms. Nielsen's motion related to temporary order. First, let me just ask, Ms. Nielsen, did you serve Mr. Roy any documentation related to your motion?
So at the time when I filed and sent it off, I had sent it to his lawyer he had and just found out probably about a week and a half, that he no longer had a lawyer. I wasn't exactly sure how to go about that, seeing as when I sent off the papers, I sent it to his lawyer he had.
When you sent off the papers to his lawyer, did you fill out what they call either an affidavit or a declaration of service indicating that you had mailed that off?
I believe so, yes.
Okay. When I checked the file, I didn't see that. So I'll double check again. So reviewing that file and also double check the 304 matter to see if it may have been filed there. I don't see it there either. So that declaration or affidavit of service is the way that the court knows that somebody has mailed something or has served somebody with documents, and without that, there's not evidence that that has been served or given to the other side. So at this point, without service on Mr. Daly, we're not in a position to go forward. You would have to make service on him of the documents related to your motion, and then you'd have to docket it for a future date.
Okay. Do I have his lawyer that he had send me back the copies that I sent him?
You could certainly check with the attorney. I don't know whether the attorney would still have those documents. They may not. I kind of doubt it, but you can certainly check with Mr. Brungart.
Okay.
All right. So any questions on that, Mr. Daly, on that particular matter?
Your Honor, I also have a quick question before we go.
Yeah,
How would I possibly get papers to Roy?
Nelson. So I had a question for Mr. Daly. Mr. Daly, do you have any questions on the stance of the case?
No, Your Honor, I do not, but it would be nice to have those papers.
Okay. Then Ms. Nielsen, you had a question?
Yeah, how would I get him the papers?
That's something that you can check on washingtonlawhelp.org. That's a valuable resource that you can check on how to serve people documents. Another resource would be the CLEAR hotline, CLEAR. That's a line staffed by licensed attorneys, and they can give you some legal advice on how to serve people.
Okay, and I currently don't have his address either. So if I, like, when I do get him served, I have no known location for him.
Okay. Mr. Daly, have you filed any documents in the case?
No, I have not, Your Honor.
Sometimes people, when they're involved in a legal matter, will ask for or will agree to service by email. Some people will agree to email service so they have the documents so they know what's going on so they can be prepared and defend against any particular matter. What do you think about that?
Yes, email would work for me.
Okay. Some people feel comfortable sharing their email over Zoom, others don't. What's your preference?
I can do the email. I personally would rather have him have the paper copies.
The question was posed to Mr. Daly. What's your preference?
I'd rather have it emailed.
Okay. And do you, as far as preference, sharing it, your email address over Zoom? In other words, are you comfortable doing that or no?
Yes.
Okay, go ahead and share your email. All right. Ms. Nelson, did you get that?
Yep, I got that.
Okay. So if you will serve a copy of those documents on Mr. Daly, then then file an affidavit or declaration of service and file that with the court, and then docket it for a future date, and then we can be back here and address your motion.
Okay, thank you.
The other matter we need to address before you leave, Ms. Nelson, relates to Ms. Looney's involvement in the case. Ms. Looney?
Thank you, Your Honor. So we have filed a motion for temporary child support orders. We have asked for that to be set for April 24th. My understanding is that there was no request to address child support today.
Okay.
The other question I had for Your Honor is whether or not we would be consolidating the cause numbers. It appears that the most recent filings were done in the 304 cause number rather than the 125 cause number. That's where we had filed our motion as well. So we weren't sure which cause number would be the accurate one to use.
Yeah, let me touch base with Mr. Daly and Ms. Nielsen. There's competing matters that have been filed. So the first is the 125 case. That's where Ms. Nielsen has filed a petition for a parenting plan and child support. And then in the 304 case, that's a matter that was filed back in July of 2000. Actually, let me hold on a second. I think I messed up there. Yeah, sorry, let me go back. Let me restart. So back in March of 2023, Ms. Nielsen filed her petition for a parenting plan and child support. And then in July of 2023, Mr. Daly filed his motion via Mr. Brungart for parenting plan and also child support. It's the same issue. We're dealing with Paisley and her best interests and the parenting plan there. Does either party have any concern if we were to consolidate the cause numbers into a single cause number, which basically just merges them into one file? Everything that's been filed before continues to be filed and is available to the court and to the parties to review. It just makes it administratively a little bit easier. So there's just one cause number, and all the issues that each of you have raised would be addressed. So does either party have any questions or concerns about that? Mr. Daly?
No, you're not, Your Honor.
Ms. Nielsen?
No, I'm fine with that.
Okay. And then Ms. Looney, you indicated that the most recent motions were filed in the 304 case. Is that correct?
Yes, Your Honor.
Okay. Any strong preference, Ms. Looney, as far as which one is the receiving case?
If we could do the 304, that's where we've already filed our paperwork, and that's the cause number we're operating under. If the parties don't have a preference, that would be ours. That has the most information in it currently.
Okay. And again, like I said before, all information that's been previously filed in both cases would be available to the court. So I'm fine with that. The 304 case will be the receptacle of the 125 pleadings. So from here on out, we'll work with the 23304 cause. Ms. Looney, would you be in a position to prepare and submit an order of consolidation and submit it to the court and provide copies to parties?
Yes, Your Honor, we can do that.
Okay, great. Thank you. And then also, Mr. Daly, I see that there was I think there was an address in, let's see, address on 19, still a good address?
For mailing, it would be, Your Honor.
For mailing, it would be, you say?
Yes.
Okay. So Ms. Nilsson, that's also another option for you. You can serve via email as indicated by Mr. Daly, or you could serve via mail at the 19th Avenue address.
Okay, thank you.
All right. With that said, we have then Ms. Looney's matter that's been docketed for the April, tell me again the date?
24th, Your Honor.
So we'll be back at least on the April 24th to hear Ms. Looney's motion. As far as Ms. Nielsen's motion, make sure there's that service, and then you file that affidavit with the court. And then we'll look forward if Mr. Daly has any response, then we will be back here on a date docketed by Ms. Nielsen. So we'll see everybody in the future.
Okay, thank you.
Thank you, Your Honor.
Thank you, Your
All
Honor.
right, so we're here on Mr. Trotter's motion for a temporary parenting plan. And I want to double check first with Mr. Trotter. As far as your motion, did you provide copies of your motion and declarations supporting your motion to Ms. Springstead?
Yes.
Did you file an affidavit or declaration of service with the court?
Actually, I didn't know I needed to do that.
Yeah, and that's not uncommon. It's you know that you sent documents to Ms. Springstead, but I don't. The way I know that is through an affidavit or a declaration of service that says on such and such a date, a third party served Ms. Springstead with the documents or something of that nature. Ms. Springstead is present, and Ms. Springstead, did you receive copies of the documents related to the motion?
Yes, I did.
Did you submit anything in response?
No,
Okay.
I didn't know that was an option.
Yeah, so yeah, and that's another thing just to point out is that generally these type of cases, it's based on written declarations. So everybody kind of writes out beforehand what their position is and what they're thinking. And then they come to court and then they argue based on those submissions or those declarations that have been submitted. So I think with the position we're in with Mr. Trotter having failed to submit the affidavit of service and without having heard Ms. Springstead's her voice related to what she wants in the case, I think it's appropriate to set the matter over, to come back a different day, because I don't know what Ms. Springstead wants. I have an idea what Mr. Trotter wants based on his pleadings. So it would be inappropriate to move forward today without having a fair knowledge of what everybody's asking.
Am I able to verbalize that, or do we just have to have it in writing?
Yeah, there needs to be something in writing, and then when you come back, then you can verbally argue your position.
Okay.
So,
yes, sir.
Trotter.
Sorry, I didn't mean to interrupt you, Your Honor. I just wanted to ask, me and Mrs. Springstead have talked quite a bit recently, and we had actually kind of come to an agreement about maybe pulling back out of this proceeding here and coming up with our own agreement and accord in regards to our son. We're brand new to this, so we're just kind of wondering what we would do next.
Right. So yeah, it's a good question. If parties are unable to come to an agreement, lots of people come to an agreement on legal issues. And if they can't, then they come to court and then they'll ask a third party, the court, to make a decision. So my general rule is, and it doesn't always hold true, but my general rule is that if you all are closer to the situation and know it much better than I ever will, if you can come to an agreement that's even-handed, non-pressured, no coercion, then that's preferable in a lot of ways than the court making a decision. So if the parties want to make an agreement, there's nothing that prevents the parties from submitting agreed orders related to parenting plan. And then that could be submitted to the court. Both parties sign off on it. The court signs it, then it's done. So that's one option. You certainly don't have to do that. If there's areas of disagreement that you can't overcome, then you come to court and state your position in written form and then ask the court for a decision. Does that help, Mr. Trotter?
Yes, sir.
Ms. Springstead, do you have any questions?
I did have a question about the paperwork, but if you're saying that we need to put this over, then maybe it's not appropriate to ask at this time.
Yeah, I mean, with the paperwork, I'll just throw out a couple of different options. There's places you can look. There's a great website. It's called WashingtonLawHelp.org. If you type in family law or parenting plans or what have you, they have all the forms there. They have documents that explain things, how to do things, and the information that you need to file that. And then also, if you have documents that you want to have reviewed, a courthouse facilitator, which is a member of the clerk's office, can take a look at any agreed orders that you might have come up with and make sure that all the T's are crossed, all the I's are dotted to make sure everything's okay. So kind of where that puts us right now is that Mr. Trotter has filed a motion. We can't hear it today because there's no service upon Ms. Springstead of those documents, and Ms. Springstead hasn't filed her response. So I only know one side of the story. So generally what we do when that happens, we just don't hear the matter today. And then we ask Mr. Trotter to serve the documents on Ms. Springstead, file his declaration of service, and then file a docket notice, basically putting it back on a particular court date and give notice of Ms. Springstead of that. So that's kind of where we're at. Questions, Mr. Trotter, either or?
My question was, can you repeat that? Washington Law Help, was it .gov or .org or?
WashingtonLawHelp.org, O-R-G.
All right, thank you, sir.
Welcome. Ms. Springstead, do you have any questions?
How would I go about filing the response? Like, is that, do I pay? Do I have to go to the clerk and get a different paperwork?
Yeah, that's a good question. To file a response, a couple of different sources. There's particular forms. Family law is form driven, so there's lots of forms online. If you go to a website, it's courts.wa.gov, and then you type in forms. So you look for the forms, and then you go to the family law section, and you can look for a reply or response document, and it's in Word format if you have access to a computer, and you can just type it up, print it, and then file it with the court, and then send a copy to Mr. Trotter, and then file an affidavit that said, hey, on this date, I mailed it to Mr. Trotter, or I handed it to him, so the court knows that you've given that document to him.
Okay.
So courts.wa.gov, that's where you can find forms, and also the WashingtonLawHelp.org also has the forms there too. So two sources.
Thank you, Your Honor.
Welcome. Any other questions? Mr. Trotter?
No, sir. Thank you very much.
Okay, so we'll look forward to the parties submitting. You're free to negotiate and come to any type of agreement if you want, and if you do, then you can submit those to the court. Go ahead.
Sorry, I do have a question about that. If we do come to an agreement, do we sign like the paperwork that he already had filed and re-enter it, or is it like a whole new process and a whole new filing fee, or how? I'm not sure how that
Nope,
works.
the case is open. The case is open. So this case would be the receptacle or the receiver of that information or those documents. And so if you come to an agreement, say you come to agreement on a parenting plan, that parenting plan you could find at Washington Law Help or at the courts.wa.gov form site. If somebody would print it out, you'd make all the necessary notations, and if everybody feels comfortable, you can sign it, and you submit a copy to the court and ask for it to be signed, and then it'd be signed, and you'd be notified of that.
Okay, thank you, Your Honor.
Okay.
Thank you again, Your Honor.
All right, with that, we'll conclude the matter for today.
Okay.
Yes, sir.
Okay, welcome to you. Welcome to you, Ms. Powers. And Ms. Looney is present. We're here on a motion brought by Ms. Powers related to a motion to transfer the case to mediation. And I'll double check with Mr. Menning. Did you receive a copy of Ms. Powers' motion?
Yes.
Okay. And did you file anything in response to her motion?
No.
Are you in agreement with her request?
In regards for the mediation?
Yes.
Yes, I'm in agreement. I'm fine with that.
Okay. And then Ms. Powers, it sounds like there's no disagreement from Mr. Menning, and you submitted a proposed order related to that. Let me just open that up right here. Yeah. Give me just a second. There it is. In your proposal, let me check with Ms. Powers as far as the division of financial responsibility for that. In your motion, I can't remember if you were requesting a 50-50 split or something different.
50-50 split, Your Honor.
Okay. And Mr. Manning, is that your understanding?
Yes, I'm in agreement with both of us splitting the cost of mediation.
Okay. Let me just take a moment while we're right here and just to type out the order, and I can print it up, and we can finish that portion of the case.
Your Honor, the state would have a request. I'm not quite sure how to address it in the order, but the children are receiving TANF. So the state would be asking that there be no mediation regarding child support, as under the law, we would not be able to do any sort of a residential credit regarding child support. If there was a custody split, we would need to enter the order with the standard calculation.
Okay. Thank you, Ms. Looney. So, Ms. Powers, do you have any questions about that comment that Ms. Looney just made related to mediation not including child support?
So if I'm understanding correctly, we won't be mediating child support. We'll just be mediating assets and parenting plan and alimony. Is that correct then? Okay.
Yes. Yeah, I think that's a fair statement.
Okay. Then, yeah, I think I understand.
Okay. Mr. Manning, any questions about that?
Other than the income stated on the child support order is inaccurate.
And so certainly that would be a topic for mediation.
Your Honor, we've sent out a motion for a temporary child support order. I think that may be what he's referencing. We have a hearing set for that on April 17th. So obviously, Mr. Manning would be able to submit to the court and to our office any additional information he has regarding his income for that hearing.
Does that answer the item that you're addressing, Mr. Manning?
Yes.
Okay. Let me just take a moment, see if I can just, I'll type up this order and then just review it with everybody. And then if you have any questions, we can talk about it.
Okay.
Okay, thanks for your patience. So the order reads related to the order transferring case to mandatory mediation indicates that the mediation service shall be paid 50-50, petition 50%, respondent 50%. The party shall mediate the following issues: parenting plan, any residential time, and other issues as specified below: division of property, division of debt, spousal maintenance. Anything else on that?
I don't believe so, Your Honor.
Okay, Mr. Manning, any other items you think of?
Not at this time, Your Honor.
Okay, thank you. So Ms. Looney, does that address your need as far as just basically not discussing a parenting plan, child support at that mediation?
Yes, Your Honor. Thank you.
All right, very good. And then it indicates mediation shall be provided by Community Mediation Center or any other agency approved by the court. Then I have the listing of the names of both parties based on those addresses and phone numbers we talked about. And then it says that a copy of the certificate of mediation disposition, basically when it's done, shall be filed with the court by the mediation center within 7 days after it's completed. So with that, that's the order, and I'm prepared to sign off on that. Any concerns?
So I was just wondering, because I've never done this before. So how do I go about, like, when I turned in all my paperwork, I turned in my pay stubs and everything. Do I need to do a discovery before mediation, or will mediation help with all of that?
That's definitely a topic that you can raise with the mediation center to see what type of information would be helpful for them in mediating with the party. So I would double check with them.
Okay, thank you very much, Your Honor.
Yeah, Mr. Manning, do you have any questions?
Not at this time.
All right, so I'm just going to take a moment and just finish up the order here, so I don't lose it when I close it out. And Ms. Looney, I'm going to include you just on the signature area where it indicates that you're present via Zoom, if you're comfortable with that.
I am, Your Honor.
Okay, and then Ms. Looney, your motion is set for what date?
April 17th, Your Honor.
Okay, so just be aware that there's that motion pending brought by the state, and so the parties would be anticipating being present on that day to argue your respective positions. Do you have any questions on that?
I don't think so.
Okay, and Mr. Manning, do you have any questions on that?
No, Your Honor.
Okay, very good. So I'm printing right now the motion for transferring the case to mediation. That's printed, so it'll be back on the back printer. I'll get that filed, and then if the parties need a copy of that, you can check with the clerk's office in 2 or 3 days, and they should have that available.
Okay.
Any final questions, Ms. Looney?
No, Your Honor.
Ms. Powers, any final questions?
So will I just call and work out a date with Kyle that works for both of us and schedule a mediation?
Yeah, I think so. You can contact the mediation center and see how they want to do it. Sometimes they may involve themselves in that. I'm not quite sure how they set up initial dates, but if you and Mr. Manning can kind of solidify some dates beforehand, or maybe you call the mediation center and say, what are some available times? And then you can share that information with Mr. Manning, or Mr. Manning can call him and share that information with you, and then just choose a date.
Okay. Thank you, Your Honor.
All right, very good. So with that, that'll conclude Ellsworth's motion for adequate cause to modify the parenting plan and also change parenting or change child support if there were to be change. So I see that service was effectuated back on February 29th, and I read Ms. Ellsworth, your motion and your request related to modifying the November 2019 parenting plan, correct?
Yes, Your Honor.
Okay. And then I read from you, Mr. Cooper, you filed a response to the petition, and you're basically disagreeing with those proposals with just a few kind of brief comments, but not a lot of substance. Is that true?
So I did respond with an adequate cause, but I'm not sure if it got to you in time.
Okay. So was it a declaration that you filed giving more detail of why you disagree?
Yes.
Okay. And when did you file it?
So I filed it on the 22nd.
And did you serve a copy on Ms. Ellsworth?
Yes.
Okay. Did you get a copy of that, Ms. Ellsworth?
I got served with the adequate of cause and payment of cost, but I didn't get like a declaration.
Okay. Let's make sure we're talking about the same thing. So Mr. Coop, the document I'm looking at, if you look in the top right corner underneath where it says Cowlitz and then the cause number 16.3, underneath that it says motion for adequate cause decision to change a parenting plan amended. That's the one that I'm looking at that Mr. Cooper submitted. And it's a 3-page document.
Yes, Your Honor, I have it.
Okay. And then Mr. Cooper, beyond that document, did you submit any other documents?
No.
Okay. All right. So in that document, let's see, one moment. And I'm also looking at Mr. Cooper's motion for payment of costs. I'm looking at that also. All right. So, Mr. Cooper, so with your response, so Ms. Ellsworth filed a lot of paperwork. She filed a motion for adequate cause. She filed a petition to modify the parenting plan. These are back in February that she filed them. There's a motion to adjust child support. There's a proposed parenting plan. She submitted a financial declaration, a proposed child support worksheet. She also submitted a declaration where she wrote out why she's asking what she's wanting. There was also then when we see your response where you say, basically it's that checkbox document where you say either you agree with certain things or you disagree with certain things. And then there's just a line or two for you to explain why you disagree or agree. So I see that. And then I see, then you filed another motion for adequate cause, kind of repeating what Ms. Ellsworth was asking for, that there be adequate cause. So where I'm at, I'll just tell you where I'm at. I know what Ms. Ellsworth wants fairly well because I have a lot of information from her. On your end, Mr. Ellsworth, I have that checkbox form that says basically you disagree, and there's some scant reasons or not fully explained reasons why you disagree. So if you're comfortable moving forward with that, we can address the matter today. So I'll ask Mr. Cooper if you want to move forward to today.
Move forward to
address the motion for adequate cause to modify the parenting plan.
Okay, yeah.
Okay, all right. I'll hear from Ms. Ellsworth. Go ahead and just explain your position related to why you feel that there's adequate cause to change the parenting plan, and then what it should be, and then we'll hear from Mr. Cooper on those same topics.
Absolutely, Your Honor. I did respond with a declaration yesterday, which you probably have not seen yet. But I am basically asking for adequate cause because 2 years ago, back in 2022, I have moved back into the local area from Montana.
Right.
So I feel like being closer, I should have more time with Leo than every other weekend. And I would like for him to be able to bond with his other 3 siblings as well.
Okay, and so that's kind of your main point there is that you're back from Montana, came back in like July of 2022.
Yes, Your Honor.
And that you have a stable home. And then there's 3 other siblings in your home.
Yes, Your Honor.
Okay. Anything else?
That's the majority of the reason I feel like there's enough cause to be able to modify the parenting plan we have.
Okay. All right. Thank you. And Mr. Cooper, what's your position?
So Your Honor, I disagree. This is our 3rd parenting plan we have, and I feel there's no no good reason for us to change what we have. I have been cooperative with Miss Ellsworth. We've worked it out to where we finally have it in another written statement where where she can see him when she wants, as long as it falls through with this third parenting plan. And I just don't feel that we need to change it. Or
Okay. Anything else?
Sorry, it's breaking up.
I was just curious if you have any other comments you want me to hear related to your position.
So other than we've already had 2 other parenting plans that we've established, and she has broke both of them. The reason why we have this parenting plan in place is because she violated the first 2. And so that right there was the main reason why we had to fill out this third and final parenting plan.
Okay. Anything else?
That's all.
All right, thank you. And Ms. Ellsworth, anything in reply?
Yes, Your Honor. I disagree with that. The very first parenting plan we did have, we mutually agreed with, and we had signed at his old lawyer's office, Daggy. And then I had moved, and then which I regret doing. So we got that second plan, and I remember him wanting to just make it from temporary to permanent. So that's what changed into that second parenting plan, which has been since I think either 2018 or 2019. So I disagree with that. And this plan I have not violated at all. I've been following it as it has been. And when I was in Montana, I did get Leo for 2 to 3 months at a time, which isn't in the plan. So like he did let me have him more, but that since I'm here now, I think we need something to be able to have him more, and because I'm in the local area.
Okay. And in which city?
I live in Longview.
And Mr. Cooper lives where?
And Kelso.
Kelso. Okay. And Leo's how old?
9.
9. Okay.
So, Your Honor, the reason why she had to move back is because we ended up having to go and get the state police in Montana to track her down. This event took little over a year just to get her, to force her to come back down to state, because she was refusing to let me see Leo, let me talk to him. She took him out of state, and the judge ruled that she was withholding my son from me. It was supposed to be on a weekend that I was supposed to get him, and she ended up leaving the state, and we had to go through a whole ordeal just to bring her back.
Okay. And let me just double check with the parties. It looks like there's been contempt hearings in the past, and I see the most recent one was back in January of 2019, so it's fairly old. Okay. And how many contempt hearings? It looks like in at least the January 2019, it looks like Ms. Ellsworth was held in contempt related to failure to return the child to Washington back in December of 2018. So I'm just looking, part of the statute that talks about adequate cause talks about contempt if a parent has been held in contempt previously. So I'm just double checking that. So it looks like there's 2 orders of contempt from January 31st of 2019. One relates to the parenting plan, didn't obey the order signed on December 7th, 2016. And then the other that was filed on that day indicates that there was a contempt by not following the court order from December of 2018. So it sounds like it's similar conduct covered by 2 different orders. Is that accurate?
I think so, Your Honor.
Okay, Mr. Cooper, what's your vantage point?
I stand the same. This is why we have this parenting plan in place, and I don't believe we should change it.
Yeah, I'm asking specifically about the contempt orders. It just looked like there's 2 orders of contempt. Is that your understanding?
Yes.
Okay. Thanks. Okay, so the revised Code of Washington 2609-260 controls adequate cause decisions. And what it says is that the court shall not modify a prior parenting plan unless there's been a substantial change that's occurred in the circumstances of the child or the non-moving party. So either Leo there's a substantial change in Leo's situation, or the non-moving party here, which would be Mr. Cooper. And then also there's a requirement that the modification be in the best interest of the child and necessary to serve the best interest of the child. It goes on to say that the court shall retain the residential schedule or the parenting plan unless the parents agree, or the child's been integrated in contravention of the existing parenting plan, or the child's present environment is detrimental to the child's physical, mental, or emotional health, and that the harms likely to be caused by a change is outweighed by the advantage to the child, or the court's found the non-moving parent in contempt, meaning Mr. Cooper, at least twice in the prior 3 years, which is not the case because we reviewed the contempt issue. So what I understand is that the current parenting plan indicates that there's some limitations, what we call 191 limitations on Ms. Ellsworth, that there's joint decision making. The primary custodial parent is Mr. Cooper, and that Ms. Ellsworth has visitation on Friday, 5 p.m. to Sunday at 5 p.m. When in the local area. So that's the current portion or setup. And Ms. Ellsworth has indicated that she's moved back from Montana some time ago, and that she has a safe, stable home available, and the 3 other children need their sibling, and they need to be together. So in my view, that does not rise to the level of a substantial change occurring in the circumstance of the child or in the circumstance of Mr. Cooper. So I'm going to deny the motion for adequate cause. So yeah, I'll deny that. So that means we don't get to the petition to modify the parenting plan without the adequate cause. That's kind of the first step. If that's achieved, then we move to the motion to modify. And so since the adequate cause says there's not, then we don't get to the parenting plan modification, and we don't get to the child support modification because there hasn't been a switch of the primary parent, and that relationship. So that's a long way of saying the motion for adequate cause is denied, and then the other 2 things we don't get to because of that.
Okay, Your Honor.
So any questions on your end, Ms. Ellsworth or Mr. Cooper?
I have a question. So do we still have to go to court on April 10th? For the payment of cost and his adequate costs?
Yeah, so that's where Mr. Cooper has filed a motion for payment of costs. So at least that issue's at issue. So that's set for April 10th. Okay. So that would be a future date. And then just to clarify, Mr. Cooper, your motion related to adequate cause, are you asking for a motion for adequate cause to modify the parenting plan?
No.
Yeah. Okay.
It was supposed to be for this current one, but I didn't realize it's been a hectic week between my attorney, so I just turned it in a little too late.
Okay. All right. So yeah, so we'll be back here on April 10th on Mr. Cooper's motion related to payment of costs, not the adequate cause, because we've addressed that today.
Okay.
Mr. Cooper, any final questions on your end?
No, sir.
All right. That'll conclude today's hearing. Thank you. All right. Lisa Weed, if you're on the line, make sure you're unmuted and state your name, please. All right, Lisa Weed. All right. In the courtroom, we have just one individual. That's not Lisa Weed. And then again, I'll just double check. I'm going to check the participant list by typing in the name Lisa. We see that she's present in the Zoom call. Yes, so I saw that you sent a text or a message and that you're working on fixing the audio.
Thank you. I just had to plug in my mic. I don't know what's going on with my audio. So I'm half on headphones and half on here. Thank you for waiting.
Okay, very good. This is a motion brought by Mr. Hampton for contempt related to a parenting plan that was issued back in February of 2019. I reviewed the pleadings by both parties, so I'll hear from Mr. Hampton first and then from Ms. Weed in response. Mr. Hampton?
Yes, Your Honor. Thank you. Good morning.
Morning.
So here Lisa she's got quite a bit of a response, so I'm going to try to summarize it and skim over it as best I can to try not to eat up too much time. If there's anything that's of concern to you, you can stop me at any point. I'll start.
Maybe I can just kind of cut to the chase a little bit. You're indicating that you haven't seen the child since December 24th of last year through February 11th when you had filed.
Correct.
Okay. And just to kind of winnow the issues down, you're you're making allegations that there's a violation of the parenting plan because you're not getting communication from the schools, doctors, and counselors, and that you're making an allegation of verbal abuse and false allegations, insulting, cursing, not being positive, not answering calls, and then also that another individual is being called dad. So those issues. Are you claiming that those are violations of the parenting plan, or just concerned about those issues?
Both.
Okay, so let me just ask, where in the parenting plan does it prohibit or require that communication from the schools, doctors, and counselors comes to you, and Ms. Weed isn't in charge or responsible to getting that information to you? Because I looked in the parenting plan, I couldn't find that.
Okay, well, it just states that there's supposed to be an open line of communication, I believe. I haven't recently looked over the parenting.
Okay, so and then
one of the big key points that I wanted to touch on. Go ahead.
Yeah, let me check then. Also, as far as verbal abuse, false allegations, insulting, cursing, is there anything in the parenting plan that prevents the parties from doing that? That there's a strict prohibition or a prohibition that prevents that from happening?
Again, I haven't read over the parenting plan real recently, but I do remember that when we put the parenting plan into place, that was one of the big aspects of it was communication and being positive.
Okay, and then just a final question to make sure, this is kind of my winnowing questions to help focus the argument today. As far as another individual, sounds like the significant other of Miss Weed, that the child is calling him dad. Is there any prohibition within the parenting plan that prevents that from occurring?
Absolutely.
Where does it say it in the parenting plan?
I'll have to get a copy of that so I can read off which page it was, but I know that was absolutely put in the parenting plan that he was not to do that, because that was an issue observed by the guardian ad litem herself.
So I'm looking at the parenting plan, the most recent from February 26th of 2019. And I'm looking through each page, talks about decision-making, dispute resolution, talks about who's the custodian, talks about parenting time schedule, gives times and dates, talks about summer schedule, talks about holiday schedule, it addresses transportation arrangements, if there's conflicts in scheduling, what's to happen, talks about relocation, mentions that each parent has the right to move, notification given as soon as they know that they'll be moving, and that's it. So I see nowhere in there where there's a prohibition related to that. And sometimes things are said in hearings back in 2019 that don't make it into the written order. And if it's not in the written order, then I don't consider it. So from my vantage point, the issue of the communication from schools, doctors, and counselors is not an issue because it's not in the parenting plan, as well as the verbal abuse and false allegations, as well as the calling another individual dad. So we're not going to address those because they're not in the parenting plan. And if you can find that it is in the parenting plan, please let me know. But from my view, and read that parenting plan several times, I didn't see it. So then your focus would be then from your allegation related to no visitation for the past few months. So I'll hear from you.
Yeah, there hasn't been any visitation since back before December 25th. That's just, I stated in my paperwork that was the last time I had seen Jessie. She claims that was because of some violence that was reported over Christmas about me supposedly throwing him into a Christmas tree, but that doesn't explain why she withheld him through November. There was a CPS case involving him at his school, and I believe that's why she was withholding him through November. I don't have any proof of that, but I mean, I can only speculate. There is definitely in the parenting plan, it's stated that we have to have an open line of communication.
Tell me where,
say that again.
Can you tell me where that says that in the parenting plan? Because I've looked for that and I cannot find it.
So it states that it doesn't state that she has to keep in contact with me over my son.
I'm asking you, where does it say that in the parenting plan?
Again, Your Honor, I don't have a copy of the parenting plan with me. I can, maybe I wasn't as prepared for this as I thought I was. I just feel like visitation and communication with my son, if it isn't in the parenting plan, by all means it should be. I don't see where it would be appropriate to just drop full communication with me over, text messaging and deny Jessie access to see me. I mean, if it's not in the parenting plan, it's just not morally sound.
Okay. So since December, the December 24th, December 25th, there's not been visitation. Is that correct?
Correct.
And the parenting plan calls for you to have visitation on alternating weekends, Friday 5 to Sunday at 5 with the midweek visit. Is that accurate?
Yes.
Okay. And so since that December 24th timeframe, there was no visit. I'm assuming weekend visit on the 12th of January and the 26th of January, and then also the February weekends. I assume there would be 2 weekends during that time frame. Is that your allegation?
Yeah.
Okay.
Also, I want to state that it does state in our parenting plan that we're supposed to meet at the Cowlitz County Courthouse. However, back in November of 2020, I did move to Yelm, Washington over the passing of my father so that my sister and I could work together to provide care for him. And while I was up here, by April 27th, 2021, I had found work. And so I've been living up here since then. And the meetup spot being in Cowlitz County is, I feel, unfair. I asked Lisa if she could meet me at exit 88, which is approximately 45 minutes from her location and 45 minutes from my location, making it a halfway point. I didn't see that as unreasonable. I wouldn't expect Lisa to drive any further than I would have to drive. Through November, she claimed she didn't drop Jesse off to me because she didn't have enough gas money to get to me, even though I was offering her gas money once she got here to put in her tank just so I could see Jesse and he could see me. Again, that didn't happen because she said she didn't have gas money. I'd like to move the drop off point and pickup point to a halfway point just to make it kind of fair on both of us.
Okay. Anything else you want me to be aware as far as your motion for contempt?
I mean, like you mentioned the false allegations, there's allegations of violence, transportation. I think I touched on both of those. There is the texting problem we're having where, neither of us can seem to be civil to each other. She can claim that it's me starting it, and I can claim that it's her starting it. But I think to stop that whole tit for tat, I think it would be a responsible move to just use a co-parenting app. And if I don't know of any off the top of my head, but if you do, I'm open to suggestions.
Okay. Okay. All right. Thank you, Mr. Hampton. I'll turn the time to Ms. Weed. Ms. Weed.
Hello. I just want to paint a fuller picture for the court. Jesse Jr., he had relayed to me that there was some violence that took place over his Christmas visit with his dad. The way that he was acting, there was something, I had every reason to believe that something did take place. The following weekend was not Jesse's weekend, so I did not need to contact him.
That would be the weekend of January 5th.
Yes, and I was also out of town due to a family death. And I was very frustrated in my response to him. That is definitely a fact. I did mention, I needed to talk to him about that. He made no other point to reach out to me. What I'm getting is, I feel like a one-sided parent, as everything's on my shoulders to do. And Jesse claims no responsibility for it, and everything's my fault. I have him on the school documents as his father. They don't reach out to him because he doesn't reach out to them. I haven't stopped that in any way, shape, or form. There's nothing on file that says he can't reach out to them and speak with them, in which he has every right to. He is his dad. I do care about their relationship as a mother. I believe that both, all kids need to have both of their parents. However, the violence, I have no way to protect Jesse Jordan from his violent outbursts, and I don't know what to do about that. It's been an issue in the past, and this time it was very significant to our child. He is still very angry with him. He still is very frustrated. He doesn't know why it happened. Jesse has special needs. He has severe ADHD, possibly autism, and you have to have a lot of patience with him. And I don't think that maybe Jesse did have any patience with him that day. He still has not even asked to go back there. he talks about it. He talks about it angrily. He mentions it. I've talked to him about it, and he's scared. He scared him so bad. I just fear that if I send him back up there, that this is going to keep happening. And I go through a lot with Jesse's behavior. I am the one that goes to the school meetings. I'm the one that picks him up from school when he has rough days. He has an IEP. He is on medication. And if any calls come through and Jesse is not having a productive day, they send him home. And I'm the one that has to leave work and go get him. Jesse's never once taken him to the doctors. He's never once taken him to a counseling appointment. He's not once had an emergency phone call from the school where he's had to pick him up. He's just not available for that end of being a father. And it does create a lot of stress for me. I do want Jesse to be there in his life, but he can't just do half of it. And then everything else is on me. And then on top of it, he, the way that he talks to me about being assaulted or domestically abused, I can't even fathom it, like the way that he speaks to me in regards to abuse that has happened to me. If anything, I've gotten a restraining order. I got a restraining order. I haven't been around my husband, and neither has my kids, and I filed for a divorce. There's not much more I can do after the fact. I can't control people's behavior, but I can leave the situation.
With regard to the restraining order, can I ask you a question on that?
I'm sorry. Can you repeat the question?
Yeah, with regard to the restraining order that you just mentioned, was that obtained after the December episode?
I got a restraining order against Nicholas Stoddard for abusing me in front of my children. He is my husband.
So it doesn't relate to Mr. Hampton, the restraining order?
No, it's not related to Mr. Hampton. No, and he did not touch my children.
Follow-up question for you, if I may, Ms. Weed.
Absolutely.
When your concerns were raised in end of December related to the safety of your child, did you seek out any type of protection order, restraint order that would say, hey, look, there's concerns here related to the safety of the child. There is a parenting plan that says dad gets time with the child, but because of these new concerns, the court says, hey, we're going to stop those visits for now.
No, I did not. I was trying to speak to Jesse about it. He never reached out to me. So it's always on my shoulders to reach out to him and to fix whatever he would like or whatever problems he has. I have to focus on my kid. I just wanted to make sure.
When you were concerned for the safety of your child, did you reach out to the courts? Because there's an obligation under the parenting plan for visits to occur. And your concern is that if the child goes over there, he's not going to be safe. And so if there's a court order that says that's supposed to happen and then it's not happening, then basically you need a court order that says, gives you permission not to do that, which would be like a parenting or a protection order that says, well, there's enough here to stop visitation. Did you seek out that from the court?
No, I did not, sir. I wanted to speak with Jesse about it. However, that just didn't happen. We weren't able to speak about it. I did relay the information to a welfare child check that happened on February 20th as to the reason why Jesse hadn't been there, and Jesse still hadn't reached out and contacted me about anything to talk about it. Perhaps I went about this the wrong way. I have tried to reach out because the parenting plan, I believe, stated that we needed to report to authorities and to CPS. That I've tried to reach out to CPS prior to this incident regarding another incident concerning violence, and they said that they do not take reports from biological parents against other biological parents.
So you called?
I could have still reached out to the police. You're right. You're correct. I could have done that.
So did you reach out to CPS and ask them, or did you try to make a report related to the December episode?
No, I didn't, due to being discouraged in the past.
Okay, gotcha. Okay. All right, thanks. I think I have a pretty clear picture of your position, Ms. Weed. Any final items you want me to be aware of?
Just 1 second. Let me get through here. I believe I've asked for a specific time frame of supervised visitations. Just to make sure that this is not going to keep occurring, as it affects him terribly.
Okay. All right, thank you. All right, so here the allegation is that the parenting plan requires alternating weekend visitation with child and father. Apparently there was an episode on December 24th where Ms. Weed indicates that the child was thrown into the Christmas tree by Mr. Hampton, and thereafter she was concerned for his safety and then withheld the child from Mr. Hampton. The parenting plan indicates that the visitation is to occur. It's difficult when there's concern for the well-being and safety of your child, assuming that there was something untoward that occurred on December 24th regarding the safety of the child. The court frowns upon what they call self-help. In other words, if there's a court order that says X needs to happen or that visitation needs to happen, then the court anticipates that. If there's intervening causes or new things that come up that the court's not aware of, having made that earlier decision for the parenting plan, the court's the one that's in charge as far as altering that parenting plan. So thus the discouragement of self-help, because that tends to be a little more messy. So here, Ms. Weed indicated that she did not seek out a restraining order or some type of protection order that would supersede the parenting plan and prevent the visits from occurring. She indicates that through CPS, she was discouraged and was told that a parent can't make a report, which I don't think is correct, and I could be wrong, but sure seems reasonable that a parent would be in a fairly good position to have some concerns and have those concerns investigated. But you might want to revisit that with CPS and clarify that. Mr. Hampton indicates that he has concerns regarding the exchange location. The exchange location in the parenting plan, again, this is the controlling document that the parties need to be familiar with, indicates that the exchange is to occur. It says Cowlitz County Courthouse, Castle Rock Middle School. That's what the parenting plan says as far as an exchange location. So if the parties have concerns related to that, if they are requesting a change, then you need to file a specific motion for that to be altered. Regarding communication, one app that I've seen that many parties have used is Our Family Wizard. Our Family Wizard. There's a co-parenting app or a parenting app. There's several that are out there, and I've seen that one used with some regularity. Our Family Wizard. So I'm not making a ruling on that. That's just an option for the parties. It records everything, so there's a record of all communications.
Thank you.
So, so the concern is that, one, we want children to be safe. Two, we want parties to follow parenting plans. And three, if there's needs to be an amendment or change to a parenting plan because of something that happens that the court wasn't aware of before, that there needs to be, the court needs to be involved in that process. And recognizing that you all don't do this for a living and this isn't something you in the water that you swim in every day, I recognize it's not, but there's a parenting plan there. So can I fault a parent for withholding visitation from another parent where there's concerns related to violence? That's difficult for me to do, and yet at the same time there's an order in place and there's remedies. There's potential remedies to protect the child, and the court's involved in that process. So I'm going to grant the motion for contempt, finding that there was withholding of at least 2 weekend visits, if not more. I'll impose a $100 civil sanction, no other penalties, and I'm not ordering makeup time at this point. So the parenting plan is in place, and it sounds like there's concerns related to the child and the child's emotional well-being. And so if the parties are concerned related to either altering the parenting plan and the visits, then you're free to ask the court for a motion related to that, whether you're asking for supervised visitation or what have you. So at this point, I'll draft that order, making a finding that Ms. Weed is in contempt with the civil sanction, and no makeup time is ordered related to those missed visits. I think in part just because of the allegations related to the alleged violence that occurred at the end of December. Sounds like the parties probably need to tread lightly and caring for your child and going forward. Children are really sensitive to things like that. If something did occur, and there may need to be some type of counseling intervention to help smooth that transition back. So at this point, those are the issues that are before the court related to the contempt. So any questions on that? Otherwise, I'll just draft an order and get that filed, and the parties can get a copy of it.
No questions, Your Honor.
Mr. Hampton, any questions?
Yeah, I just had one. Is it possible we can have the court fees split between the two of us? I feel like it kind of took two of us to get into this position, so I feel like that's something. the court fees for today.
And what are those?
There was a waiver I was supposed to fill out when I did all this to fight. It was a waiver for the court fees. Apparently, I was under the assumption that this was going to cost us money to be here today.
There's no charge for being here today.
Okay.
Yep. So since there's no charge other than the expenditure of your time and energies, I'll deny any motion for repayment of costs since there has been no outlay of costs.
And one more question: is it okay in the meantime until I can get the modification of the parenting plan? Is it okay if I have a third party meet with Mrs. Weed there in either at the courthouse or at the middle school in Castle Rock?
So I won't give any advice related to how the parties negotiate and work under the parenting plan. The parenting plan is what it is. It's not terribly clear as far as exchange location. So the parties are encouraged to figure that out. And if you can't, then come back to court and ask for relief. And I know you're asking for the relief now, but the other party needs to be given notice prior to coming to today, and that has to be served upon her. So if you're asking for a particularized relief, you have to write it down, file it with the court, give her a copy, and give her an opportunity to respond, and vice versa. So that'll conclude today's hearing. Thank you. He's on the line.
Yes, I am. I just have one question.
Go ahead.
I gotta pick up my nonverbal kid. He gets out in a couple minutes. Are we able to go next or no?
That's kind of why I called your case next. Okay. Situation is that we'd be handling this now. So are you available?
Yes, I am.
Very good. Tiffany Giske, are you on the line?
Yes, I am.
All right. Court investigator Ms. Schaefer is present. I can see her. Can you hear me okay?
Yes.
All right. Very good. I reviewed the family court investigators report, and I'll ask if Mr. Giske, did you get a copy of that review or that order, or pardon me, that report?
Yes, I did, and I read it.
Okay. Ms. Giske, did you?
Yes, I did.
Okay. Very good. So I read over Ms. Schaefer's report, and basically she has some recommendations as far as a psychosexual assessment, supervision at all times, not being left alone, unattended with the other children, and schooling, wait until an assessment is completed, and basically not altering things at this point. Ms. Schaefer, anything to add to that kind of summary?
No, that's about all, Your Honor.
Okay, thank you. I'll hear from Mr. Giske and Ms. Giske related to, and this is basically Ms. Giske's motion to modify the parenting plan, and Ms. Schaefer has chimed in related to that. So I guess Ms. Giske, since this is your motion and we've heard from the family court investigator, I'll hear from you, Ms. Giske.
Bobby was actually the one that started this whole thing over these accusations.
Did you file a motion to modify?
Yes.
Okay, so I'll hear from you.
Okay. I just feel like both of the boys both need both parents, if at all possible. And I do believe that Ms. Schaefer's orders to get the help that he does need sounds correct to me. And I feel like it would possibly help him more than what's being done.
Okay.
And I do have a quick question.
Okay.
At our last hearing that we were at on February 14th, I believe it was, Bobby said that Junior was seeing a psychologist, but in her report, he told her that he's only seen his counselor. So I'm just confused on who he's seen because I don't have access to that since he has the parental rights.
Okay. Mr. Giske, can you just answer that discrete question?
Yeah, Columbia Wellness, before they can be assigned a psychologist, they got to see the med doctor. He has been scheduled. The doctor got sick, so he's scheduled for the beginning of next month. I think it's like around the 7th or the 12th. And then after that, he will be issued a psychologist after meeting with the medicine doctor.
Okay, thank you. Does that help answer your question, Ms. Giske?
Yes, thank you.
Okay. All right, anything else you'd like me to consider, Ms. Giske?
Not at this time, no.
Okay, thank you. Mr. Giske?
Not really. I read her report. Her report's true, other than I do know the difference in behavior and supervision between my house and her house. I mean, he's already at my house for schooling as it is. So I personally do feel that the longer he is there, it behaviorally and mentally affects him.
Okay. Thanks. All right. So at this point, there's some obvious concerns that are related to at least two different episodes. And there's potential, I guess, pending review by a prosecuting attorney out of Clark County. So that's still up in the air. So we don't know what's going to happen with that. I think, let me just double check with Ms. Schaefer. Do you have any additional comment after hearing from the parties?
No, Your Honor.
Okay. So I think given those concerns that have been brought up in the pleadings related that the psychosexual assessment is absolutely necessary. Ms. Schaefer provided some suggestions. Ms. Darnell is an option. So I'm going to order the parties to make sure that happens. It sounds like Mr. Giske, you're probably in the driver's seat with that. So you're ordered to make sure that assessment gets taken care of in a timely, reasonable fashion. And as far as the supervision, that's also going to be part of the court order, that it is supervised at all times and is not left ever unattended with other children. And that the schooling issue, we're going to hold off on that until that assessment, that psychosexual assessment is completed. So for now, there's not going to be a change of parenting plan. So I'll deny the motion to modify the parenting plan. If there comes a time when there's been additional updates or an assessment has been completed and there's maybe some change or there's some improvements or what have you, then certainly any party's free to bring a motion to modify or seek relief. So I'll ask the parties if you have any questions related to the court's ruling.
I do not.
No, sir.
Okay. So what I'll do, I'll prepare an order denying, I think it was a December 19th, maybe December 2023 motion that was filed by Ms. Giske, December 19th. And I'm just going to do a quick notation here. So I'll deny the motion to modify, and then I'm also separately entering an order that requires the psychosexual assessment, the supervision requirement, and then the schooling. We're waiting on that until further information. So those are the two orders that I'll file. So you should have access to those within 2 to 3 days of filing. I try to get those out by Friday at close of business. So probably midweek next week, those orders would be available. Any questions from any party?
Yes, I do. Oh, sorry. Go ahead, Tiffany.
Ms. Giske?
So we just go ahead and follow with our current parenting plan from 2018?
I think that's the time frame. Yeah, the most recent parenting plan controls with the addition of the psychosexual assessment, the supervision requirement.
Yeah, that's totally fine. Totally understandable.
Okay. All right. If there's no other questions, that'll conclude the hearing. Thank you.
Oh, I do. I have one question.
Go ahead.
Mia Schaefer were talking, and we had concerns because of an issue with one of the cousins that she goes to visit in Idaho, and I was requesting for him not to go over there. Ms. Schaefer as well had concerns for it.
So if you're asking for some type of relief, which it sounds like you are, you'd need to have a specific motion asking for that specific relief, and then serve a copy on Ms. Giske and then note it up for the court to be heard. So we don't address things that haven't been filed with notice being given to the other party.
Yes, sir.
Okay. All right. That'll conclude things for today. Thank you. Cameron Miller is on the line. Cameron Miller. Next. Right. Not hearing a response from Cameron Miller. I'll ask if Taylor Young is on the line. Taylor Young. No response there. I see Miss Corey is on the line. And I'll just, once again, Cameron Miller, if you're on the line, make sure you're unmuted and state your name. I'm not hearing any. Go ahead.
Mr. Miller is currently incarcerated in Lewis County. He was properly served on March 12th at Cowlitz County Jail.
And did you verify?
I verified that he is still on the jail roster this morning.
Any indication as far as release date, if he's pre-trial or post conviction?
I don't know.
Okay. So do you have any? So I read over your motion, and I'm not I understand what you're asking for. You're asking that for a contempt finding that for willful failure to pay, without him being present. He has been served and he hasn't filed anything in response. What is your position as far as moving forward today?
I don't know.
That's a fair answer. That's okay. It sounds like he was served March 12th at the Cowlitz County Jail, and then he's now at the Lewis County Jail. And I'm not exactly sure what happened there. Sometimes people may resolve a matter here, and then there's a holdout of another county, and they get transferred immediately there. It's pretty difficult to file a response. Not impossible to file a response from jail, but it is a little more challenging depending on the level of paper and access to the internet and the like that one may or may not have. This has been a long-standing issue that goes back many, many months, if not close to a year. Not knowing the length of his incarceration, I think what I'd like to do is just give it one more week. Let's set it over one more week. And Miss Corey, if you could alert me at the beginning of next week's docket, because sometimes there's a lot swirling around as I begin a docket.
I am actually out of town next week.
Okay. Maybe would you be averse if we were set it over to the 10th of April?
The 10th would work.
And if you could remind me on that date that your matter's fairly short, and we could call it first, and so you don't have to be on the line as long.
Okay. How do I need to notify him then of that new date? And
that would be appreciated. I mean, that would give the court more confidence of moving forward. If he has been given notice of the hearing on that particular date, then he could make arrangements with the Lewis County jail officials to get him present via Zoom.
would I have to actually serve something on him? The reason I ask is because before he was in Cowlitz County incarcerated, he was in Lewis County the first time, and then before that he was in Thurston County, and then a tribal jail. So he's been incarcerated for quite some time, and most of those places actually charge you $60-$70 to serve.
Do you know if I'm assuming that somebody who's incarcerated can receive mail and receive a docket notice?
Oh, good idea.
Maybe that would be one approach. To at least he's given notice, and then he can make arrangements with the county jail folks, and with the 2-week time frame, that should be adequate.
Okay, thank you.
All right, we'll be back on April 10th. I'll ask if Mr. Miller is on the line.
Yes, I'm here, Your Honor.
Okay, welcome to you. And then I'll ask if Ms. Amezquita is on the line.
Yes, I'm here.
Okay, welcome to you also, ma'am. We're on today for Ms. Amezquita's motion for contempt related to communication and not using the parenting app. And it looks like there was service of that motion on Mr. Miller back on March 11th. And we were here previously, and I'm not sure, Mr. Miller, have you filed anything with the court related to a response to that motion for contempt?
For that, I believe that issue was the last judge we had, I can't remember her name. She'd said the app was unreliable. I know it was working for me at first, but then it started cutting out. It kept kicking me off. I wasn't able to get on it. So I've been having a lot of technical difficulties using the app. And I know she's talked to my grandparents. My grandparents have told me that they have talked to her and told her that the app has not been working for me, and I have not been able to get on the app.
So did you file anything since March 12th when the motion was served upon you?
I don't believe I have.
Okay. So at this point, Ms. Amezquita's allegations stand unrebutted. So I'm in a position to grant her motion for contempt. And I'm not sure why you didn't file anything.
Oh.
Okay. So at this point, Mr. Miller has indicated that he's had some technical difficulties related to the parenting app. There's an order from June of 2023 that's the app that's to be used by the parties. Ms. Amezquita alleges that Mr. Miller is not using the communication app. He doesn't open up the messages, and she showed documentary proof that the messages remain unopened and unread, and that there's not the communication regarding their mutual son. So that's kind of the varying viewpoints on the issue. Anything else to add to that, Ms. Amezquita?
I've talked to his grandparents about calling me too, like using his phone to call and have our son talk to me. He hasn't even done that. The only time I get phone calls are whenever our son's at the grandparents' house. Like we communicate sometimes about me calling them or they randomly have him call me, but I never get a phone call when he's with his father. I get no communication at all, even like through texting or anything.
Right. And I'll give you the final word on that issue, Mr. Miller. Anything else you'd like to add?
Yes. As for text messages and phone calls, I know I've always been okay with her communicating me through that. And I know phone calls, she's aware that she can always call to talk to her son. I'm not trying to withhold him or anything or say she can't talk to him. I just know that usually her supervised visitations are up with my grandparents. So at the time, usually it's maybe I'm working at the time, and that is usually the easiest way for her to communicate with him, especially on the weekends.
Okay. All right. Thank you. All right. So in any motion for contempt, the court looks at the underlying court order. This is the court order that relates to the proposition was filed on June 9th of 2023. It's entitled Court's Interim Ruling. It indicates in paragraph 2, communication between the parties is authorized and shall be done through our Family Wizard parenting app. This shall be the method of communication for the parties, regardless of the status of the protection orders. So that's the controlling provision related to the motion for contempt. Mr. Miller indicates he has technical problems. The order's been in place for roughly 9 months plus. And if there's a concern related to a court order and there's an inability to follow through or comply with that, the expectation is the court would be made aware of that. And if there's difficulties, then it could be adjusted. Here, there's not an explanation related to efforts to control or to fix any potential technical issues related to our Family Wizard. So I'm going to grant the motion for contempt and impose a $100 civil sanction against Mr. Miller that he'll need to pay. And then the parties are also reminded that 2003 June order still controls regarding the communication. So that our Family Wizard app has to be through which the communication occurs. That's the baseline. If parties want to use a telephone to make phone calls or video conferencing, you can do that. That's basically, that's something you can do. But if there's not agreement with altering or deviating from the court order, then you have to go with the court order. But if there's agreement, certainly you can deviate from that. So I'm going to take just a moment to give myself a notation here so I can prepare that order. I'll get that order drafted and the parties can take a look at that. It should be filed no later than on Friday afternoon. The next issue is that I had asked the parties to submit additional information through pleadings related to the parenting plan, because at this point there is no parenting plan. There's kind of this interim ruling from June that indicates Mr. Miller is the primary parent related and having non-emergent health care and the like until there's a parenting plan issued. So we don't have one at this point. And so I asked the parties to submit additional information, which you both did, and I'm grateful for that. There's enough information that's out there that's, I think that what I want to have additional information through the appointment of a family court investigator. Here, the indication is Ms. Mesquita wants a 50-50 type plan. There's concerns related to foreclosure where Mr. Miller is living. There's concerns for domestic violence in both homes. There's concerns of videos and violence and video games and the like. So I think it's appropriate at this point related to, and also there's the concerns of Mr. Chaddock and Ms. Mesquita's home. And I recognize that it looks like he completed the DV course, the 24 week course. I recognize that also. So what I'm going to do, I'm going to appoint the family court investigator, Ms. Schaefer, to speak to the parties and investigate a little bit further to gather more information so the court has a more clear picture in addition to the information that you all have submitted here just recently, which I'm appreciative of. So in the interim with that order, I'll appoint her as the family court investigator. She'll be contacting each of you. As far as contact information, I believe the addresses and phone numbers were filed in your most recent pleadings. So Ms. Mesquita, you've got and then with Mr. Miller, I've got a number.
Yes, that is correct, Your Honor.
So that'll be the information that Ms. Schaefer uses to contact you. So she's going to do some investigation, and then she'll file her report, and that'll be noted up on a docket so we can address the parenting plan. I think there needs to be a parenting plan put in place, at least on a temporary basis, so there's greater clarity, and so the best interest of the child can be preserved more precisely. So again, I'm just going to take a minute to write down a note so I can prepare that order. And also, until that next hearing, I'm ordering that neither party utilize corporal punishment on the child. That means no spanking, no slapping of hands. There's just to be no physical punishment of the child. Certainly there can be timeout and other means, but no forms of corporal punishment. Any questions from the parties on that point?
No, Your Honor.
Ms. Almaskita?
Yes, I had a question. So my protection order is gone. What about my supervised visitations? Like, what goes on with that? Because that was with the protection order.
That's part of the issue. That's part of the issue is that right now, the only kind of parenting plan guidance that's at the end, at least that I can find, and you can point me to something else if I'm missing it, is from June of 2023, where it's noted the court's interim ruling related to communication, getting a domestic violence evaluation, indicating that Ms. Almaskita is to have supervised visitation with the child to be supervised by the paternal grandmother, assuming she's willing to do that. And you're available to have up to 8 hours of visitation a week with the time and place to be agreed. And the parties can choose to break that up into multiple visits. And the visitation shall happen only with Ms. Almaskita, and Mr. Chaddock shall not be a part of the visitation at any time. So I would just point to the parties to that June 9th, 2023 interim order as the kind of the guiding document at this point until we get more information from the family court investigator and the court issues a temporary parenting plan.
Okay.
Any other questions from you, Mr. Miller?
No, Your Honor. Thank you.
Okay, Ms. Almaskita, any questions from you?
No.
All right, so I'll get those orders out. And again, the family court investigator, please promptly return her communications, and then we'll be back on that as it's docketed, once she has her report completed.
Okay, thank you.
All right, that'll conclude the hearing. Thank you.
Your Honor, may I say something?
Tell me your name.
My name's George Miller. I'm the grandpa of Buddy. I'm the one that filed with CPS and started all this. As far as visitation,
what are the names of the parents involved?
My name's George Miller.
What are the names of the parents involved?
Mike Miller and Angel. I can't pronounce her last name.
So we just had the hearing. You probably heard what I said, and so you're not a party. So we'll rely upon what I said in that case. So you can address any concerns at a later time. We're done with the case for today. Fierst, correct? Your last name Fierst?
My last name isn't fully changed until I can get a hold of a human being for my medical insurance.
What's your preference? What would you like?
Fierst.
All right. So we have Ms. Fierst present, and then Christopher Zimmerman. Are you on the line?
Yes, Your Honor.
All right. And Ms. Corey, are you on the line?
I am.
All right. Welcome, Paul. So we're here on the guardian ad litem report that was filed on February 16th. She filed that, and I'll check with Ms. Fierst. Did you receive a copy of that report?
A copy of the final parenting plan or the guardian ad litem's final report?
Guardian ad litem.
Yes.
All right. And Mr. Zimmerman, did you receive a copy of that document?
Yes, Your Honor.
Okay. I reviewed that, and guardian ad litem, based on that information provided therein, makes some recommendations related to primary custody to the father and alternating weekend visitations and midweek visits to Ms. Fierst, and either party can request a UA. Ms. Corey, anything you would like to highlight with regard to your report?
No, but the parties have since come to an agreement.
Okay.
That does differ a bit from my final report, I would ask, but some of the other provisions remain.
The agreement between the parties, has that been submitted to the court, or is that just something that's you're aware of?
It's been submitted to the courts.
Yes.
Okay. And do you know if it's been signed by the court? Anybody can answer.
I am unaware.
Not that I know of. I was told that you would be getting a copy. I even paid extra to make sure it came straight to you. I thought that's my understanding is that's what was going to be happening today.
I have a parenting plan in my possession that looks like it's signed by both Ms. Zimmerman, Ms. Fierst, and Mr. Zimmerman, dated respectively the 12th and 13th of March. So that's what you're talking about, correct, Ms. Corey?
Yes.
Okay. So this involves the two girls. And
Girl and a boy.
One girl.
oh, sorry, my apologies. How do you,
okay.
how do you pronounce?
It's okay. Our son's name is very unique, and you pronounce it.
Kenai.
Yeah.
Okay. Please extend my apologies to Kenai.
Okay.
You're okay.
There's a request that you're agreeing upon joint decision making. And as far as the parenting plan, you're making a recommendation that Mr. Zimmerman be the custodial parent of Kenai and Ms. Fierce be the custodial parent of Sarah. Is that correct?
Yes.
And that there would be a 50-50 time split with exchange on Wednesdays, 1 week on, 1 week off, one child on Tuesday, both on Wednesdays. So help me understand what that looks. Basically,
So the one day would be extra for more time with each parent, with give them time an extra day of the week to have one-on-one time with the parent. That way, because the siblings have a rivalry issue that is actually quite prominent. And so they fight a lot. So this will give them one-on-one time with each parent one day of the week.
Well, and since then, we talked about trying, because him and I have been on the same page, and just kind of learning as we go what works best for the children. And we are switching Sarah on Sundays and Kenai on Wednesdays. So that way it's half the time without each other and then half the time with each other, and also even for both parents.
and are the children, they cross paths, they don't reside in the same home for any period of time?
They do for half the week.
Yeah.
Okay. All right. And then they just take a look at the other provisions in the parenting plan that's been submitted.
I do believe that that's the only two things that I've changed about the whole thing.
Okay. All right. Having reviewed that, I'll hear from Ms. Corey.
I actually like this plan better than the original one. Good job, you guys. I realize it's a little bit out of the box. But as we know, parenting plans always work better when they're coming directly from the parents. This parenting plan actually, though, does reflect pretty much what they were doing before this case was brought. So it, but I'm okay with it.
Okay. And just confirming with both Ms. Fierst and Mr. Zimmerman, are you okay with this proposed order that's been submitted that we just reviewed?
Absolutely. I feel that it is in the best interest for both children with their mental health, because I know that parenting plans can have a significant effect on the children, regardless of if they have involvement directly or not. The outcome always has its effects on the children, and this will be, it shows the children that we are working together to try to give them the best opportunities to be around each other with both parents, as well as giving them separate time from each other to prevent them from having their issues, and hopefully it will be easier to grow a stronger bond between the two of them doing this, as well as, when I first filed for the modification, since then, Desiree's circumstances have improved dramatically, and I'm comfortable with this order, and I feel that it took us a while after a 15-year marriage and then a sudden divorce to build the communication, because things were awkward, things were strange, there was animosities, but since then we have both grown in our own lives, and yeah, we have a healthier communication now. So.
Okay. All right. Thank you.
Also, from our past experiences of trying to do this, whenever all of the responsibilities have been on either parent, we've both, during those times, have become very overwhelmed. So that's where we came to a compromise to where each of us are, legally responsible for just one child, parent the other. And we did it the way that we did it because with Sarah being at her older age, she feels more comfortable with mom and I could be more involved in that kind of stuff. And as Kenai gets older and matures, then he's got his dad as well. And I feel like we both have the best interest at heart when it comes to them. So I love how we have it.
Okay, thanks.
Your Honor.
Go ahead, Ms. Corey.
I would also request that other than the actual residential recommendation from my report, if the court would be willing to adopt the other recommendations from my final report regarding both parties taking a parenting class, either party able to request a UA from the other party and the appropriate language for that, and that both parents take steps to assure the children's attendance at school.
Okay.
I did already look up on your guys' site when I was looking up which courtroom court was today. It popped up different parenting classes that are available. And Chris and I have both discussed that, trying to work together to find one that will be suitable for our schedules with working and parenting the children and their schedules. And I don't have any disagreement with the UA part of it at all.
Okay, and what about the school provision?
I got those printed out as well and turned those in with the parenting plan. They are doing a lot better with both attendance and with their grades because they're able to get more one-on-one help. And also I was able to get the children their own alarm clocks at my house. And so that seems to help a lot better as well too.
Okay, so then if I'm hearing you correctly, Ms. Pearson, you don't have any objections to those three items being included in the parenting plan that you've presented today?
Absolutely not.
We'll hear from Mr. Zimmerman.
The only issue I have is it's just going to have to be finding a parenting class that I'd be able to do on the weekends on my days off, because during the week I can't even schedule doctor's appointments for myself. I'm on call. I work all day and sometimes all throughout the night, depending on when they call me. I transport railroad workers for a living to and from their trains. And so they call me any time of day or night. So trying to schedule something is next to impossible. But if we can find a parenting class on the weekends, I am absolutely all for all of it. So
okay.
I have some parenting classes that are done online that might be a good choice for you.
Awesome.
Yeah, I was also informed as well and was looking into it over here at which online courses are available, and I was going to get back to him too. But if you're able to help with that, that would be amazing and take a little bit off my plate.
Okay.
I'm going to email you guys a link.
Thank you.
Perfect. Okay, great. Well, I appreciate the effort made by both Ms. Fierce and Mr. Zimmerman. In large part, setting aside any differences between themselves to focus on the well-being of your children. That's beautiful. That really speaks well of you both, and obviously a benefit to your children. So thank you. I'll sign off on the parenting plan. I will add the provisions related to the parenting class for both, and the UA provision. I'll include that. Then also the school attendance provision as laid out in Ms. Corey's recommendation section. So I'll just add those, and then I'll get that filed, and then the parties can get a copy of that for your records.
Okay, thank you so much.
All right, that will conclude the matter for today. Thank you. And he's in the courtroom. He's
day.
coming forward. If you can make sure just in front of the microphone, that'd be great. And then Megan Rhodes, are you on the line today?
I am.
Okay, welcome to you. All right, and then as far as the guardian ad litem, we'll ask if Mr. Lawrence is here. He is. I can see him. Can you hear me okay, Mr. Lawrence?
Yes, I can.
All right, very good. Thank you. We're here today for a couple of different purposes. One is to get a review from just kind of an initial review of the 30 days of a post-appointment of the guardian ad litem. The other is to address the Ms. Rhodes' motion for temporary parenting plan. So with that said, maybe we could start with Mr. Lawrence. We'll hear from you related to your appointment and efforts, and then we can hear from the parties. Mr. Lawrence.
Yes, Your Honor. I've had a chance to reach out to both parties. As the court may recall, at the last hearing, Mr. Robinson was living in, his address was listed as Vancouver, but he indicated he was living in Chehalis. and that came as a surprise to Ms. Rhodes. I had an appointment scheduled for this last Friday to meet with both of them. Mr. Robeson visits with his daughter at Ms. Rhodes' home. And Ms. Rhodes felt uncomfortable with that. And in her words, she had him trespassed, so he couldn't come to her home anymore. So on Friday, I was able to meet with Miss Rhodes and got to see Nora, and we had a full interview. I got an email from Mr. Robinson indicating that he wanted to reschedule. I called him back and left a voicemail, and I just recently got an email from him giving me his current address in Chehalis, and I have emailed him back proposing 2 home visit days, either on Tuesday or Wednesday of next week, and I'm awaiting his reply. So that's where we are from my end of it.
Okay. I replied back to you this morning and said Tuesday at 3 o'clock works.
Great.
All right, great. Well, good. Well, I appreciate the good communication, but between Mr. Lawrence and both Ms. Rhodes and Mr. Jensen, that's fantastic. That's what we're hoping for, is to have that good communication continue. So I appreciate that.
Well, me and Ms. Rhodes are no longer in contact. She said that she wants me to go through her attorney, and I don't know who her attorney is anymore, or now.
Okay. Let's pause on that just for a second. Mr. Lawrence, anything else on your end as far as updates?
Not at this point, Your Honor.
All right, great. Thank you. Ms. Rhodes, as far as the court file, that shows that you're still representing yourself. Is that accurate?
Yes, it is. I did speak to an attorney, and she is the one that recommended that I cancel home visits at my home moving forward until we have a temporary parenting plan in place. Just because also when we were at court last time, you were talking to somebody else about how difficult it is to get a child back if another parent takes that child. So I just have a lot of safety concerns as far as Chris is concerned.
Are you representing yourself?
Yes.
And is that your plan moving forward, representing yourself?
As of now, yes.
Okay. All right. All right. So at this point, we've kind of finished the first portion of the hearing related to the guardian ad litem. The next portion, it relates to the Ms. Rhodes' motion for a temporary parenting plan, which she filed back in February. So I've read the input from Ms. Rhodes, and I've also read the input from Mr. Jensen. So Ms. Rhodes, this is your motion, so I'll hear from you, and then we'll hear from Mr. Jensen. And then before we do that, let me just double check with the parties. The guardian ad litem has been appointed to do some investigation, and that's largely aimed towards a temporary parenting plan. And so he's just getting going with his investigation. Sounds like he's met with Ms. Rhodes, and he'll be meeting with Mr. Jensen on Tuesday afternoon this coming week. With that being on the horizon, he will gather that information and talk to other people, and then he'll write his report, which is directly addressed to the parenting plan and the best interest of the child or children. So I'm just wondering if it would be prudent to pause on this motion related to the temporary parenting plan brought by Ms. Rhodes until we have that more full information from Mr. Lawrence. I'll hear from you, Ms. Rhodes.
So that is basically what I would also like. So I filed a new temporary proposal, but mostly just stating that I think that the living situation needs to be investigated. And if, Mr. Lawrence deems that it's a safe and stable and healthy living situation, then I would be fine going to like a more traditional parenting plan where Chris could have Nora maybe every other weekend. But as of right now, it just doesn't really feel very safe or very healthy, just from my perspective. So I just want Mr. Lawrence to have the time to look into something like that before I'm would feel comfortable just sending my baby over there.
And that's where you would send in an updated parenting plan where your recommendation was a Thursday afternoon start time to Monday morning for residential time for Mr. Jensen?
Yes, every other weekend would be what I would like. But again, that would be, following the investigation that Mr. Lawrence does. Because if there are issues with the home, with the living situation, with the stability of all the stuff, being that both of them, just got out of treatment, it's a new relationship. Like I have concerns about, where's my baby going to sleep? What's the house like? Things like that, where it's like, I don't know this person at all. And that's, 45 minutes away from me. And I've been the primary caregiver her entire life. So I just want to make sure that she's safe prior to agreeing to that. But if, like I said, if Mr. Lawrence deems it safe, I would be happy to agree to something like that.
All right. So your preference would be to hold off a bit on the motion until we hear more from Mr. Lawrence.
Yes. Or even if we could set up, I know that there is, I don't want to keep Nora from him. If we could even plan on doing just like, I know there's a facility in Longview that does supervised visits. I would be happy to set something up so Chris would be able to see her there while we're waiting for Mr. Lawrence to do his investigation. Because I don't think that it's fair to Chris that he's not seeing her at all. I just don't feel comfortable with him taking her, and I don't feel comfortable with him in my home.
Okay. Mr. Jensen, the question I kind of interested in hearing from you and your response as far as holding off on this motion for the temporary parenting plan until we hear more information from Mr. Lawrence.
You know, I just want to see my daughter. After court last week, me and Megan had like agreed upon me going to her house twice a week. I never did anything wrong to like make her second guess that. I never took her out of the house except for when I asked. So this is all news to me last week or previous court day when she texted me and said no longer visitations. But I just moved into a new house. We got a 4-bedroom house. She has her own room. I just got everything I need for her crib. Getting a car seat this weekend. I have like diapers. I have everything I need for her. So
how old's Nora?
1.
She's 1. Closer to 1 or closer to 2?
She just turned 1 on the New Year's Eve.
Gotcha. Okay.
So yeah, I don't know. I just want to be able to see my daughter, you know.
So Ms. So I think in part I'm comfortable postponing the motion for the temporary parenting plan until we get more information from Mr. Lawrence. In the interim is kind of the next step in the interim until we make that decision as far as what the visitations are.
I'm sorry. And also, so I'm meeting with Mr. Lawrence next Tuesday.
Right.
I don't know how long it takes to do a report, but can we come back like next Wednesday and get it so maybe I can have it next weekend?
So yeah, as far as Mr. Lawrence's report, I don't want to rush him. He's got a lot of work in other cases too. Right. Obviously, every case is important. So that's why we're talking about kind of an interim to give him time to do his report in an unhurried, reasonable manner. Come back and we can take a fresh look at things. Your request is that you want to have some visitation in between now and the time we get his report.
Yes, and I feel supervised is unnecessary. I mean, I haven't done anything wrong since we've been going through this process. Like I had Nora all by myself at Megan's house. She had no issues until last week, or 2 weeks ago. So I don't know what happened there. So
Ms. Rhodes, as far as a supervisor, sometimes supervised visitation can be pretty expensive depending on the amount during a week. Are there some lay supervisors that you'd feel comfortable with?
Not locally that I would feel comfortable. So I don't know how to go about that, honestly.
When you say locally, what does that mean?
Like, I mean, I don't know anybody that would also like want to or would be willing to even spend time with Chris to supervise.
Okay. Mr. Jensen, do you have any potential people that could act as a lay supervisor?
I'm not sure.
Okay.
Your Honor, there is a review hearing scheduled for April the 24th at 9 a.m. I should be able to get enough information about the home, Mr. Jensen's new girlfriend, to be able to at least answer some basic questions as to safety for visits.
Okay.
It's a month away.
It is a month away, right?
Yeah.
So I think it's important that there be visitation. Child's young, and so the frequency of visitation is important. There's also some concerns related to that are just haven't been vetted yet, at least from the court's perspective, that Mr. Lawrence will be investigating. He'll have an update for us end of April. So I am going to allow visitation to occur with Mr. Jensen and Nora, the party's child, and recognizing the expense involved there. And the reason I say expense is that there's no party has provided an option of a lay supervisor. So at this point, it'll be professionally supervised. It can be up to 2 times per week for up to 4 hours each visit. And so there's a couple different places. I know there's a professional supervisor outfit here in Longview. I'm assuming Lewis County has something there also, but the parties can do that, and they need to make arrangements prior. And then as far as the visitation occurring, then it would be 2 times a week for up to 4 hours each visit. So that'll be the interim until we get back here on April 24th, where we can take a look at things fresh.
So you said that's expensive?
You know, I think it's expensive. I think they charge 25 an hour
40 an hour.
I believe it's 40, Your Honor.
or 40 an hour. So that's why I say expensive. It adds up quick. It adds up really quick. So that's, I think, given the current status of the case, I'll draft that into an order that I'll get filed and the parties can take a look at. And then we'll be back here on April 24th to take a look at things fresh.
Sweet.
Okay.
So also I was hoping that we could address the financial declaration that he provided to me. So he does not have his girlfriend's income listed in section 4B. Also, he has two jobs.
We're done for today, Ms. Rhodes. We've addressed the issue that's before us, which was the parenting plan and the 30-day review. So any issues related to financial status will need to be saved for a different day.
Okay.
All right, that'll conclude the hearing. Thank you.
Since Mick, oh, she's done already. She said that she no longer wants contact with me. Like, I can't contact her. So how do I go about this visitation situation?
She's not on the line, so we're not necessarily free to discuss the issue. You know, there needs to be some type of communication related to setting up a visitation. So, you know, maybe sometimes voice contact is difficult for parties that are struggling to communicate. So maybe text messaging might be a better way to go. As long as
she text me back, I've tried to text her multiple times since then, and because I've said it's messed up that she doesn't allow me to see my daughter now. Thank you, Your Honor.
Maggie Sills is on the line. Maggie Sills, if you're on the line, please state your name. All right, I'm looking at the Zoom participants. I don't see anybody with the name of Maggie Sills. I'll ask if Bradley Sills is on the line.
Yes, Your Honor.
All right, welcome to Mr. Sills. Just for the record's sake, there's nobody else in the courtroom besides myself and the courtroom clerk. And in reviewing the participants, I'm just looking down the list there if there's anybody that may be considered or possibly be Maggie Sills. Again, I'll ask Maggie Sills, if you're on the line, please unmute and state your name. Maggie Sills. All right, I'm not hearing a response. I show that a service of the motion and associated paperwork was effectively served upon Ms. Sills. And then we hear, Mr. Sills, you've brought motions to appoint a guardian ad litem and a motion for a temporary parenting plan and family law order. And I think, if I'm not mistaken, and you can correct me if I'm wrong, that did you file proposed orders?
I believe I did a proposal and a temporary parenting plan.
Okay, great. Let me just look through I have a folder here with various documents, so give me a moment to review that. Okay, I don't see a proposed order therein, or orders. So with Ms. Sills not being present, and I'll double check with Madam Clerk if she had received any communication from the clerk's office related to any party trying to get into the hearing.
Yeah.
Okay, and I'm going to double check. Okay, so the clerk indicated no. I'm going to look through my inbox to see if there's any indication that somebody's trying to get in.
I know 2 weeks ago she had signed in under her maiden name, Maggie Connick, but I'm not seeing that name as a participant either.
Okay, let me check one other item or area. So when we were here last, which was March 13 of this year, both Mr. Sills and Ms. Sills were present, and there was a request to set the matter over, and it was set over to today, and the parties were notified of that. So I'm not sure why she's not here. And so I'm in a position to sign off on the proposed orders that you had filed previously. So let me double check on that. So there's a proposed parenting plan. Mr. Sills, you submitted that, it looks like on February 20th. Does that sound right, related to Ashley?
Yes, Your Honor.
So what I can do, since that's the document that was served upon Ms. Sills, I can print that and then sign off on it. So I will do that. So give me just 1 second to note this. That's the parenting plan that was filed on February 20th, 2024. So I'll print that off. I'm going to hold off on the appointment of a guardian ad litem since we have the temporary parenting plan that was requested by Mr. Sills. Do you feel comfortable with that, Mr. Sills, of not appointing a guardian ad litem and just have the temporary order in place?
I would prefer a guardian ad litem just to kind of get the final order, just to kind of have a third party without bias, just
Chime in.
yeah, I don't know that or feel that I'm wrong with my temporary parenting plan, but I just to make it fair between both parties, I feel like appointing a guardian ad litem, there would be no bias against either party, so I feel that makes it fair and just on both sides.
Yeah, I'm comfortable with that. Mr. Sills, let me ask you, in making that appointment, there's a couple of things I need to ask you about. One is what is your gross and net monthly income?
My gross is, I believe, 3,200, and my net would be about 2,800.
Okay. So let me just put that here. Okay. So then also there's when we appoint a guardian ad litem, which I'm fine doing, we have a list of the next available guardians ad litem. We have the next 3 that are available, and we give each party an opportunity to strike one of those guardians ad litem within that 3. So I'll ask the court clerk to tell us the next 3 names, and then if there's any one of those guardians ad litem that you prefer not be on there, then we would strike that person. Then it would be the next person on the top of the list. Any questions about that?
No, Your Honor.
Okay, we'll hear from Madam Clerk.
Ann Height, Keith Lawrence, Twyla Corey.
Mr. Sills, any of those that you would like to strike?
Ann Height.
Okay. So she's stricken. That leaves Mr. Keith Lawrence next. So I'll appoint Mr. Keith Lawrence.
Disregard that. Not Ann Height. Ann Height would be who I would select.
Okay, she's on the top of the list, so you're waiving any strikes. So I'll appoint Ann Height to serve as the guardian ad litem. As far as the division of payment, it looks like they're both gainfully employed. So we'll split the percentages there. The representation is Ms. Sills has a monthly net income of 4,300, and you, Mr. Sills, have a net of 2,800. So that'll be a proportional split between the parties of what that amount is. So I'll get that order appointing guardian ad litem filed, and then the parties, if you want to take a look at that, probably I'll have it filed no later than Friday afternoon, and then 2 to 3 days after that, you can get a copy from the clerk's office.
Thank you, Your Honor. And would I just reach out to the guardian ad litem to set up an initial consultation or appointment?
Yeah, that's definitely appreciated. The greater proactivity between the parties, the better. So if you want to reach out to her, you can do that. The clerk's office or the court administration will have that contact information for you.
Awesome. Thank you so much.
All right, that'll conclude the hearing for today. I'll ask.
Katrina Vor's mother is here, and
Jack Carnahan, father.
Okay, so Mr. Carnahan, you're the respondent, and then it's Katrina Patricia May.
We're breaking up, Your Honor.
Oh, I apologize. Maybe one thing you can do for me that will help is turn off your video, and that will create more bandwidth.
do what?
Turn off the video.
Okay.
So we got Mr. Jack Carnahan on the line, and then I wanted to know if Katrina Patricia May Vorse is on the line.
Yes, I am.
Okay, so you in the same car together? Is that correct?
Yeah, we're in the same car.
Yes, sir.
Okay, great. Just making sure.
Okay, so
The parenting plan. Did the party submit a proposed parenting plan?
No, we haven't yet because we honestly haven't gotten that far, and we're still doing our guardianship case.
Okay. Okay, so the guardianship case. That's tell me a little bit about that case.
Mary was incarcerated back in November, and prior to that, my uncle Michael Vorse got granted a temporary guardianship over our daughter.
Okay.
And there was discrepancies about who the father was because he wasn't on the birth certificate until after the guardianship case started.
Okay, so that temporary minor guardianship case is still active.
Yes.
Do you have the cause number for that by chance?
Yeah, it's 2-3. I've never had this issue.
Yeah, that's just weird. I mean, we just listened to it for an hour, and it's just we start turning it into work. I have a really hard time understanding what's going on.
That's why I'm kind of filling in. Maybe I can turn on captions.
Yeah.
No, I like.
I'm taking a moment just to pull that up.
All right.
But we do have the parenting plan filled out. We just haven't filed it yet. Huh? This is for parentage.
Oh.
Okay, so Mr. Carnahan, in the guardianship case, looks like you were the attorney to represent, is that correct?
Yes.
Yes.
So I asked the question of Mr. Carnahan. I want him only to respond. Understand that.
Your Honor, I couldn't understand what you just asked me. The audio was breaking up so bad that I wasn't able to hear what you said.
So I posed the question to Mr. Carnahan and Ms. Morrison. I just want Ms. Morrison to answer Carnahan. So let me ask you, it sounds like somebody on the phone, and that's creating a lot of background. Are you touching the phone?
Now try.
Yeah, just set the phone down and just don't touch it.
Okay,
that's better.
So, okay, just making sure. Are you touching the phone or not touching the phone?
I'm 2 feet away from the phone.
Okay, all right, great. So, Mr. Carnahan, you appointed the guardianship case where you appointed an attorney to represent.
Yes, I had just gotten one.
Okay, and it looks like there's a guardian ad litem today, correct?
Yes, sir.
And what the emergency guardianship talked about establishing parenting, establishing that Mr. Carnahan is a child. That's what we here in this family law act.
Do you know what he said?
Yes. This is to establish parentage.
Yeah, this is established parentage. Is that correct? Is what you asked me?
Yeah, and so I'm looking at